us. It's really much appreciated. We've had a conversation with Ms. Johnson. She pointed to us some of the documents that she didn't have, we didn't have. She also pointed to us documents that she had, but had forgotten to bring them to our attention when we prepared the statement that was filed yesterday. But she, being under oath, she'll be able to take the commission through what those documents are, because there's a particular paragraph where they should have been inserted or added together with others that are already referred to there. That's the paragraph that has the statements of offense and other people in the statement that came in yesterday.
Thank you then.
Thank you, Chair, and thank you to Mr. Bodlani. We were about to deal with the witness third statement, and it's in that context that this issue arose. So perhaps if the witness can clarify the concern she expressed before dealing with her statement has been addressed. If not, where the shortcoming is, I don't think I'm clear where this lands us. I would appreciate a clarification on that. Thank you.
Sorry, Council. I hope I understood. We are with state 3.
Yes, ma'am. Okay. And the issue of documents arose in the context of dealing with statement 3, and you were given an opportunity to confer with your counsel as you had said.
May I suggest, because I did not understand Mr. Bodlani to say that anything is still outstanding, in the sense that we cannot go ahead and start with the third statement.
Nothing is outstanding, Chair. Yeah, the only issue I was placing on record
is
that there are documents
no, followed that. I got that.
Thank you.
Got that. I think let's just go.
Then we are ready to deal with your third statement.
Please, thank you.
Okay. If then you had started on your third statement at paragraph 5.
That is correct.
And you take it from there. The note should be at your paragraph 6 now.
Yes. So I wanted to then indicate, Chair, having consulted then with council, I wanted to make an addition under paragraph 5. Just for me to mention what it is, and then Commissioner will indicate if that is in order.
So, please go ahead.
Paragraph 5 reads as it does. It says the notice requires me to deal with the allegations against me testified to by Colonel Kobus Rulofse, Captain McLean, and Witness O. The allegations, as summarized, implicate me in alleged criminal conduct. What I wanted to add, Commissioners, is in this paragraph to deal with CJC 368 from page 1 to 133, all included.
page?
1
Yes.
up to and including 133.
Okay.
That is the insertion I wish to make.
All right. Are you able, off the top of your head, I know we can find it, but off the top of your head, can you just tell us what CJC 368 is?
In witness bundle 1 CJC, we have 3681.
Just a description of the nature of the document.
3681 statement and annexure. Sorry.
Apologies. This is the index to the exhibit bundle. And it's in from item 1. That's your CJC 368 to item 5.
That is
These are
correct.
the documents you referenced.
Let's leave it. Let's continue.
Yes. She was still making addition.
Or are you
to paragraph 5.
continuing with the correction, or
That was the correction,
That
or
it ends-
the addition I wanted to make.
it ends.
Commissioners, to paragraph 5.
Okay.
Okay.
All right.
Then that will then take us to your paragraph 6. And you can take it from there. Thank you.
Thank you. The allegations are contained in a docket, which is now with the PA for a decision on whether I should or not be prosecuted and further handling. This was so confirmed by the NPA on the 10th of July 2026, as well as by the witness McLean when he testified. Now that the matter is before the NPA,
Advocate Johnson, this NPA confirmation, is it in writing, and to whom was that confirmed?
Mr. Maga,
You can always come back to it. Let's just not forget it, yeah.
yes, we won't forget it. There was supposed to get that confirmation for you from Advocate Bell. Thank you. Thank you, Commissioner Baloy. Now that the matter is before the NPA on the basis set out above for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of that, of the need to have my rights protected. Thus, when I testify on those matters, I call upon I will exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. Paragraph 9. I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances. For these reasons, this affidavit is submitted to place my position in regard to the testimony of the witnesses identified above formally before the Commission. Then we skip paragraphs 10, 10(1), 10(2), and 11, and we go to paragraph 12, Commission. In summary, apart from correcting the errors identified above, the affidavit records response to the Commission's latest notice, confirms that the allegations against me are already before the NPA for a prosecutorial decision, asserts my constitutional and statutory right against self-incrimination. 13, I accordingly place this affidavit before the Commission to preserve my constitutional rights, to avoid any further prejudice arising from parallel prosecutorial processes. In conclusion, paragraph 14, lastly, I see the need to state that prior to my then scheduled appearance on 13 July 2026, I took ill and did not appear before the Commission. I placed before the Commission a medical certificate on which a dim view was taken. I have since approached my doctor for the preparation of what I believe is a medical certificate that would be acceptable to the Commission for its details of what led to me being indisposed. It will, together with this affidavit, be delivered to the lawyers of the Commission. I request that the medical condition I suffered from be not be made public. And lastly, should I be required to answer questions flowing from this affidavit and other matters in respect of which it has been determined that I would be of assistance to the Commission, the usual subject to time's notice and the right to legal representation, Commissioners, I would be willing to make myself available for such.
This is a song about.
Thank you. That brings us to the conclusion of your third statement. And once again, to check if there are any additions you'd like to make to that statement.
It was the addition that I made.
That you made
under paragraph 5.
Okay. You say you omitted to, in paragraph 5, you add that you omitted to deal with an exhibit CJC 368. That's the first document in the exhibit file or pack of documents from pages 1 to 133.
That is correct.
Now, I had indicated that after you have addressed your third statement, I will indicate to the Commission where my understanding is your legal representatives, Mr. Bodlani and his team, and I landed on the question of self-determination. And I want to test whether the rights you assert at paragraphs 8 and 9 accord with our understanding and our decision. Firstly, our understanding is you are not invoking a blanket ban on dealing with the issues that are reflected in CC 368, the documents that you say you omitted to deal with. That you invoke your right against self-incrimination in response to specific questions, not that questions can be put to you. That is what Advocate Bodlani and I understood to be the correct legal position. I want to understand whether that is your understanding as well. That questions may be put to you, and in response to each question, you then get to decide whether you invoke your right against self-incrimination.
That is correct, because I understood that is the rules under which the Commission does operate, and so there is no blanket, but it is on a question by question.
Okay. Now, because you sitting here, you do invoke Section 3(4) of the Commissions Act, You reference it there, paragraph 8. And that is, I think, in our act, what secures your right against self-incrimination. I find it interesting that you have a similar provision in the Act, in the NPA Act. And I want to see whether you draw a distinction between your testifying before the commission and what those whom you engage during course of investigation are expected to do. In this regard, I'll refer you to Section 28, sub 8, A and B. And it will be projected soon if you don't have it immediately in front of you.
Of the NPA Act,
Of the NPA
Section 28.
28, sub 8, A and B. And Section 8A reads, I quote, the law regarding privilege as applicable to a witness summoned to give evidence in a criminal case in a magistrate's court shall apply in relation to the questioning of a person in terms of subsection 6, provided such a person shall not be entitled to refuse any answer to answer any question upon the ground that the answer would tend to expose him or her to a criminal charge. Sub B, no evidence regarding any questions and answers contemplated in paragraph A be admissible in any criminal proceedings except in criminal proceedings where the person concerned stands trial on a charge contemplated in subsection 10 B or C, or in section 319 sub 3 of the Criminal Procedure Act. So, considering the position you assume in regard to Exhibit 368, do we land at a place where those that IDEC interviews and questions are in a different position to witnesses, including yourself, appearing here today? Because if I understand sub 8, as persons that you question during the course of investigation may not refuse to answer a question upon the ground that the answer would tend to expose him or her to a criminal charge. Do you have a different standard than the one you are seeking to invoke your protection today?
Don't
you please explain to me the comparison, if it is a comparison, that you are making with this section?
The comparison I seek to make is, if I understand the witness code.
Let me perhaps explain.
Yes.
And I'm asking the question because this specifically relates to a witness called before a magistrate's court. Yes.
Yes. Chair, if one has regard to sub B, 8B, it says no evidence regarding any questions and answers contemplated in paragraph A shall be admissible in any criminal proceedings, except in criminal proceedings where the person concerned stands trial on a charge contemplated in 10 sub B and C. 10 B and C below provide any person who has been summoned to appear before the ID, and then A is without sufficient cause fails to appear, fails B at his appearance fails to produce a document requested, having been sworn or having made an affirmation, one fails to answer fully and to the best of his ability any question lawfully put to him or her. That is the comparison I seek to make, which is what the Commissions Act also provides in respect of witnesses. And my reading of sub 8 together with sub 10 would suggest that the witnesses that are interviewed, I'm not saying interrogated, interviewed by the investigating director, cannot refuse to answer questions on the basis that they would tend to expose themselves to a criminal charge subsequently. They may not fail to answer any question put to them to the best of their ability. So I read 28 sub 8 to be equivalent to the Commissions Act section 3 sub 4, which means that the rights are the same, but it would appear that those being interviewed by the ID do not have the basis or the scope to refuse to answer questions, notwithstanding the fact that they may incriminate themselves. I just wanted to understand from the ID whether, is it the same right, or does the Commissions Act afford greater rights than the NPA Act does to those who are summoned by the investigating director to answer questions? Yes.
Is it 3 sub 4 that applies, or is it section 6? Because my 3 sub 4 deals with witness fees and privilege and other things. But the equivalent of this, see it in section 6 of the Commissions Act.
It's because section 6 will cross-refer you to this section 3(4), referencing the privilege applicable to anyone, I think in a match court, if memory serves me well. So they should be read conjunctively to get to a position where a witness may invoke a right against self-incrimination. And we say that that right is protected in terms of section 3(4) read with section 6. We can get to the regulations as well. The regulations, I think regulation 8 expound further on that, but we can't rely on the regulation to interpret the act.
Can I add something to this? It's turning out to be a complicated issue, and without being technical about it, the provisions speak of a privilege.
Yes.
And privilege is different from the shield of self-incrimination. It's two different concepts. Privilege, as I understand it, is about your discussion with your attorney with your lawyer. So I'm under no obligation, or our 3(4), when I say our, I mean Commissions Act, gives a witness protection not to reveal matters that are the subject of discussion with their legal representative. I didn't understand that we are in that territory with the third statement. I thought the third statement speaks to self-incrimination, which is, as we know, a completely different concept.
Yes, Commissioner, or at first blush, we get where we are thanks to the Constitutional Court letter, Secretary Judicial Commission of Inquiry into Allegations of State Capture versus Zuma, 2021, bracket 5 SA1 CC. That is the case that determined that the rights in section 3, sub 4 and 6 is the right not to self-incriminate. The Constitutional Court considered, and it was argued before it by some or other amicus curiae, that it doesn't include the right of self-incrimination, but the Constitutional Court determined that it does. They have the right not to self-incriminate. Part of the basis for that is that the Constitutional Court held in the same matter, I submit correctly so, that the rights afforded in terms of section 35(3), sub 3 of the Constitution do not apply to a person who's not an accused person. So she can invoke section 35 of the Constitution, but she may invoke 3 sub 4. This is what brings us here. We may not get a resolution. I raise it to make the point. Rights the witness seems to assert would appear on my reading to be greater than the rights afforded persons that are interviewed by the investigating directorate, and wonder whether my interpretation is correct, and should that be the case, is it not the same right? And why it is the NPA Act seems to be so stringent when it comes to the invocation of that right. I pose this question specifically this particular because she happens to be a lawyer and advocate over 30 years, and they handle these matters. I take it on the regular. I thought she might be able to shed some light, but if she can't, then it would be a matter for consideration by the Commission as we go forward. If she can't give a response now, I'm happy to leave it there, Chair.
Please restate your question, perhaps, for the benefit of Advocate Johnson.
Advocate Johnson raises in the third statement the right to self-incriminate. And we have, I think, gotten to a point where at least she and I agree that she can invoke that right in response to specific questions as we go along. Now, I consider section 28 sub 8 A and B read with sub 10 that the right she seeks to assert is not the right afforded any person interrogated by the investigating director or the directorate. And I wanted to understand if my understanding is correct or whether there is the same right. My reading of section 28 sub 8 read with sub 5 would seem to suggest that it's not. which would mean the witnesses that they, no, not witnesses, the persons that they question cannot refuse to answer on the grounds that they would expose themselves to criminal charge. And it is precisely that ground she seeks to invoke going forward in refusing to respond to questions. It need not detain us. It might be a matter that Advocate Johnson may consider overnight. I just want to know where we land on this right against self-incrimination.
What if a moment of connection could create a real shift in your life? You're invited to join the Soulfulness community. It's completely free. This is where people come every day to experience practices rooted in soul healing, the same foundation behind soul healing miracles. Through simple meditations, many begin to feel changes.
Mr. Law, may I suggest that if we leave it at Advocate Johnson to consider this overnight, you may also want to have regard to Regulation 8.2, which speaks to the